Welcome everyone to a webinar about Brexit, COVID-19 and mobile workers. Thank you so much for joining. We are running this session jointly, a joint effort between BDB Pitmans and PEM accountants. For those of you who don't know me, I'm a legal director at BDB Pitmans, specialising in immigration and employment law. And my counterpart from PEM Accountants is the excellent Kate Millard, who is first going to focus on the tax and social security and accountancy side of mobile workers. Kate is the Director of Employment Taxes at PEM Accountants. She provides employment tax advice. She specialises in international employment tax and social security. So who better to give us an idea of that side of things? We decided to do the joint webinar in this particular case because legal and tax and accountancy issues are fairly intimately interwoven as far as mobile workers go. Often on the BDB Pitman side of things, but we're asked to provide advice, legal advice on staff moving to and from the UK, and it becomes apparent that there could be tax and social security implications of whatever move is planned. And conversely, I'm sure it's the same in the accountancy world, that when putting plans together for a client that wants to move agile workers abroad, questions arise about the legal mechanics of doing so. And those situations have begun to crop up far more frequently for two main reasons. And the first is, of course, the huge increase in remote working over the past year, with many businesses forced to have staff at home, which has led to many overseas national employees returning home, either by choice or circumstance, and even UK nationals. I'm sure you've all seen reports of British people who've chosen to work from the sunny climes of perhaps a beach in Spain. I know from my own situation that the only Costa I've been near is the one on Egham High Street, unfortunately. The other one is, of course, Brexit, albeit to a lesser extent. The end of free movement has really led businesses maybe to reassess the need to have staff in the UK, given that certain hoops have to sort of now be jumped through, and there is a potential cost of getting staff into the UK. And those that still do want to have European national staff in the UK have to be familiar with the immigration issues that involves. So what Kate and I are going to do today is walk you through a few of the tax and legal issues that might arise as a result of the increasing internationalization of the workforce. So without further ado, I'll hand over to Kate. What I will say is that if you have questions as you go along, we'll do our best to answer them. If you can use the Q&A function at the bottom of your screens, which you should see there. The chat function is for technical issues. So if you have any questions, Q&A function is best. So without further ado, Kate, over to you.
Right, thank you. So I think the main thing is that Tim and I both felt we could do a whole webinar ourselves on either tax or legal. So this will just brush the surface of some of the issues, but hopefully it will show you where you need to be worried about particular staff arrangements and what you can do about them after that. So next slide, please. Okay, so there have been some tax changes as well as work pattern changes. So the main changes that I'm going to talk to you about this morning come as a result of Brexit. So when we think of employment taxes, the main two taxes that are involved for employees moving around, particularly the EU in this case, are pay-as-you-earn and withholding tax equivalents across the EU, and more importantly, the social security. It's usually social security when we're looking at people working around the EU that is the key tax to think about. Also, there may be corporate tax considerations, but as any of my colleagues listening will know, I'm not the best person to talk about those. So I will flag those, but it shouldn't be forgotten that there are corporate tax implications of people working in different places also. So the employment tax or pay-as-you-earn position hasn't really been changed post-Brexit. So the rules before Brexit and the rules after Brexit are very, very similar. There's a few definitions that will change in double tax treaties, but nothing to really worry us on the employment taxes front. So on the social security side, until the 31st of December, the EU social security regulations did a very good job of making sure that employees moving and working around the EU and the EEA had one set of rules to follow. Employers knew what they were, we knew what they were, which was helpful. And so there was one set of regulations that governed every move of every employee within that area. So then we had Brexit. So up until the day that the trade agreement was published, we had no idea what the new rules would be, or the new protocol, as it is referred to. So it was all very last minute. So I think the main issues with this area were really in the autumn last year, when people were moving because of the pandemic, but we had to try and guess what their social security position would be. We now know that from the 1st of January 21, the EU regulations still apply to moves totally within the EU and the EEA with those citizens. So the changes only affect people moving to or from or working in the UK. So from the 1st of January 21, the Brexit trade agreement does include this new protocol for employees moving either permanently or temporarily between the EU and the EEA and the UK. So next slide, please. Okay, so the EU has two overriding elements to its guidelines. The first is that you pay social security in one state only, which avoids having to pay in two or more different jurisdictions. And social security is payable usually where an employee works. So in the simplest case, if I moved, totally to Italy tomorrow and got a job locally in Italy, I would likely be paying Italian social security from day one. And that's how they want it. And one of the main reasons for these rules is the EU is very keen to protect employees' benefit positions. So when I first started doing this a long, long time ago, there was a lot of tax planning to avoid high cost social security jurisdictions. Well, these EU rules stop that, and they primarily have the employee's long-term interests at heart. So they want the employee really to pay where they're likely to retire or need things like medical benefits. There are two main exceptions, and they have carried through into the new protocol. So there are posted workers. Essentially, a posted worker is when you send an employee to work somewhere. So usually it's the employer, most traditionally, sending someone on secondment for, say, 12 months to another group company in a different country. And there are special rules governing those sorts of arrangements in the new protocol, which pretty much mirror the old rules, but I'll talk about the changes in a moment. And then we have something which multi-state workers, which is a very EU term, I know, but multi-state workers are really when you have someone who spends as little as 1 to 2 days a month working in another country. So their head office may be in the UK, and they may be a salesperson working in Germany and living in Germany the rest of the time, but they come to another country regularly enough to need to think about their social security in that country. And there are rules that essentially link a multi-state worker back to their country of residence, as long as they spend more than 25% of their time working there. So again, it's the EU making sure that individuals pay their contributions where their family lives and where they live, to try and ensure they have the correct benefit entitlement through their lives. So the main changes post-January are really where we have posted workers. Previously, people could be posted for up to 24 months to another country and still stay in their home social security system. So if we decided to send Tim off to Estonia for 18 months, he would quite happily stay on BDB's payroll, but he would need to get a certificate to show to the Estonian authorities that he was moving there. It's perhaps not the best example, but we'll send you somewhere nice like Spain instead, Tim. So that still stands, but the problem now is that has limited to 24 months under the new protocol. Previously, if you went over the 24 months, which does quite often happen and is actually happening at the moment because of Brexit, because secondments haven't quite turned out to be the cultural and work experiences that were planned. So we are seeing a few secondments extending at the moment. Where that is the case, there's no longer a provision in the new rules for the two countries to agree a longer certificate may apply. So previously you could do up to 5 years if both authorities agreed. So if Tim was going to Spain for up to 5 years, the Spanish and UK authorities, if it was in his best interest, could agree for him to stay in the UK system.
It's definitely in my best interest to be posted to Spain for 5 years.
Possibly in all of our interests for you to be posted to Spain for 5 years. However, that will no longer be possible under the new rules. So 24 months is the cap. So after that, we have potentially a lot of admin and cost, especially if someone's, say, posted somewhere like France, which has very high employer social security, that would kick in at the end of the 24 months. So when planning secondments, people need to take that into consideration now, is that A1s at the moment will be limited to 24 months. And then there are different rules at the moment for these countries that aren't strictly in the EU, but always fell within the EU rules for us. So that's Norway, Iceland, Switzerland, and Liechtenstein. So because they are out of the EU, we have to look at our underlying agreements with those countries. So as you'd imagine, we don't have one with Liechtenstein, so it's now treated as just another rest of the world type country for social security. Norway, Iceland, and Switzerland each have slightly different dates where you can be posted for. So Norway, I think I've got it written down somewhere. Norway's up to 36 months, Switzerland is 24, and Iceland you can have 12 and then another 12. And the problem is really in this modern working environment we have is there are no provisions for multi-state workers in those agreements. So going forward, any assignments to those countries will be tricky. If certificates are in place ahead of the 31st of December, as long as there aren't changes to circumstances, they can probably be extended under the old rules for all countries. So we're really looking at new postings after the 1st of January, where these new rules apply. Next slide, Melissa. Thank you. So COVID hasn't really given us many tax changes, but it has given a huge change in behaviour. So we have got a lot of employees who are stuck, particularly last spring, where they happened to be when lockdown started, often where they went for the Easter holidays. And immediately there were lots of flight bans and quarantines. And that has continued. So more recently, we've had people stuck in Brazil, for example, when the new variant arose there and there were certain flight bans. So we do have people stuck where their place of work is not usually. And at the start, I think there were quite a lot of relaxations and no one really worried about it. But over time, we're really seeing employers waking up to the fact that suddenly they may have a workforce spread across the globe because people are working at home. It's also led many employees to request to work temporarily or permanently from home, either in their home country, so they may have gone back to their normal EU home where they have all their family. Some people went to stay with relatives in lockdown so that they were near their mum or dad. And quite often we saw people who had a holiday home, not surprisingly, would rather spend the lockdown in the south of France, for example, rather than in the UK. So all of these instances, although they sound quite simple and sensible, as time has gone on, they are really starting to give rise to tax issues and legal issues for employers. Melissa? So to start with, there were lots of relaxations of tax residency rules, payroll rules, corporation tax rules across the globe. And unfortunately, there wasn't one rule in each country. So for example, New Zealand, probably because it was very locked down, had quite detailed provisions in this area. The EU and the UK mainly ease things on the social security front. Some countries didn't do anything. And that is one of the problems that employers have. Each person that asks to work somewhere different, they're potentially faced with a different set of rules altogether. So a lot of the relaxations that were around at the start, for example, the EU, if someone had an A1 certificate that was issued on a certain basis, if they were no longer in that work pattern, the EU initially said that essentially they would ignore the changes due to COVID. But as we've progressed, that has changed a lot. So the EU advice has sort of fizzled out, and each EU country is now sort of deciding what it's going to do. So the EU social security rules are still in place, but different countries are requiring certificates to show that individuals are in their home country scheme more and more frequently. So we've recently had a case, for example, involving Belgium, where the individual had signed up for healthcare in their home country when they arrived back, and the authorities quite quickly then started to ask about social security contributions. But that query is just one example of many that we're finding where action by the employee can then lead to lots of questions being asked about their status, particularly on social security contributions. And the reason this is so worrisome for employers is if social security is due in a country, quite often it won't be at our 13.8% in the UK, it will be at much higher rates. So for example, in France, employers' social security is upwards of 40% on top of what the employee has to pay. And there are differing rates throughout Europe, so it's not just one rate, and usually it's much more expensive than in the UK. And the employer quite often has to register a payroll in that country to collect the social security. So again, you then have a lot of admin fees and trying to look after payrolls in about 10 different countries, which is not easy. One thing to make sure that we understand is where people did get caught out in a different country or have chosen to work elsewhere, many of these relaxations that the employees mention to their employers when they're negotiating these arrangements, the relaxations were initially for a temporary period when people couldn't travel. And I think now we've been in the pandemic for 12 months, there have been travel windows for most countries to allow people to go back to their usual working base, which is why we're seeing overseas authorities being slightly more aggressive now, where people are marooned in other countries or have chosen to go back and work there. So I think this area of work for Tim and I will just carry on increasing. And there are other issues, which I've mentioned some of them at the bottom. Even if someone works somewhere for about 6 months, you have to think of that person's tax residence position and how has that changed by them going to live with their mum in Poland, say, for the lockdown. Social security is key. That needs to be sorted because the employee may get COVID perhaps in their home country and may not have healthcare cover if they've not signed on properly where they need to be. Does the employer need an overseas payroll? That differs by each country. And then some of the things that Tim will talk about later, there will be employment and immigration law issues arising from people being in different places and wanting to work in different places. It's not just tax and social security. And we can never forget corporation tax, particularly if you have a outward facing employee who is perhaps at a higher level, that can really affect an employer's corporation tax position in the overseas country. And I think the last thing most employers want as a result of being nice to one employee and letting them work elsewhere is to find that they suddenly have got permanent establishment or reporting issues on the corporate side in that country. So we really shouldn't forget that. And if we'd had time, we could have perhaps brought in a colleague from that area also. Okay, Melissa. So they're the main issues that we've had as a result of Brexit and COVID. And as we keep saying, the main one is that people are wanting to work in different places. So personal secondments or personal choices of workplace are more common now than when we used to see employers sending people. Although surprisingly, in a pandemic, we are seeing lots of employer-led secondments also, which is interesting and unexpected, I think. So when you have people working internationally, there are four main principles that determine how the pay-as-you-earn or equivalent social security and whether you need a payroll. They're determined on four main things that you always need to think about when somebody either comes to work in the UK or goes to work elsewhere, even for a short period. So the first is their tax residence position. So in the UK, that is determined under our wonderful statutory residence test. Anyone who's heard me speak before knows that most countries survive with a test that is about 183 days, and you're either in or out of that country's system. Ours is much, much more complicated. And it often means that we have to, and employers have to delve in fairly personal circumstances of the individual, which to be honest is the bit I like when we're doing this, because you get to find out more stuff. But you need to look at someone's family, their partner, their personal history, where they spend their holidays. Do they come home and see their boyfriend or girlfriend regularly? Do they have a home in this country? When they come home, where do they stay? Do they have a little shrine in their mum's house with all their sports trophies from when they were a teenager? Or, you know, has their bedroom been made over into a gym or an office or something? So all of these things that an employer usually would have no business speaking to an employee about suddenly become quite relevant, because the employer has to know where the employee is resident to be able to determine if UK pay-as-you-earn is due and withholding in other countries. So whenever we have a client who says, we've got an employee, we're setting up a new branch in Finland, we want them to go and live there for a year, the first thing we have to try and determine is their residence position. And that will be due to a combination of days spent in different countries, the number of days working, and how long, for example, the secondment is going to last. Something short term, like 3 or 4 months, is likely to be less disruptive than someone going to work for, say, 18 months, when they may be half in one system and half in another, which is the worst of all worlds when we're looking at tax. So residence is the first and primary consideration. The second you have to think about is, where is the work undertaken? And this is quite difficult, particularly at the moment with the pandemic, because we would usually say, what is the employee's work pattern likely to be when they leave the UK? And I think PEM is based in Cambridge, so we're very near the home of low-cost flights, being Stansted and not that far from Luton. So quite often our clients have people who spend time working, splitting their times. There'll be 2 weeks in Germany, 1 week in the UK, or vice versa. And we really need to know what the likely pattern of work is to be able to work out the tax position up front. And as you would imagine, COVID has really put a spanner in the works, I think is the technical term, in trying to work out what those work patterns are and will be going forward. So employers are having to use their crystal balls and try and work out what work patterns will be for individuals working overseas. And that again will determine tax and social security for them. The other thing that always comes in and people often forget about is the overseas obligations and reporting that you'll need to do. So there will be domestic rules in each country that you're looking at. So the domestic rules usually are what determines the pay-as-you-earn and national insurance and equivalent overseas. I'll mention double tax treaties now as well, because there may be double tax treaty relief for the individual when they go to do their tax return, because generally individuals will not have to pay tax on the same income in 2 countries. But that usually is a relief for the individual in how double tax treaties are drawn up. So one of the issues that we have is trying to get that double tax treaty relief up front in the payroll. So sometimes you get very entrenched countries who insist that 100% of income is to be taxed on their payroll, and HMRC insist on the same, which, as you'd imagine, is a nightmare for cash flow and reporting generally. So ideally, we need to find out what reliefs each country has in their payroll system up front. The UK is really good. So if they know that people are going to ultimately be taxed elsewhere on their income, elsewhere, then there will be a relief often in the pay-as-you-earn system that you can apply for to counter that. You can't just do them on your own back. You have to get agreement from HMRC. But it's one of the things that we have to take into account when we're looking how someone will be taxed. And usually you end up with a position where there may be a bit of tax payable in two countries. NIC will be in one country, but you might need to apply for a certificate to keep the other country happy. And then you may have to have a payroll in each country. And on top of that, you may, as an employer, be asked to help with cash flow a little if the employee is trying to get to grips with two different systems. Alyssa? So the rest of my slides are not going to be able to be gone through today. What they do is they set out the main sorts of issues and questions you have to ask if you have an employee going to work overseas, or if you have someone coming to work in the UK. And what I've tried to do really is more of a handout for you, because we are very limited on time today, is set out some common scenarios when people come to or from the UK, and you'll have these slides available to you, to set out the common questions and issues that you will need to look at. So if you could perhaps flick through them fairly quickly, Melissa, until there's one called short-term business visitors. So it covers short-term moves when someone goes overseas, longer-term moves, and then we look at things when people come to the UK. If you can keep going, Melissa. So this is the one I'll quickly, if you can go back one, sorry. There, that one, thank you. So I will just mention this one thing, is where you have a group, if you're part of a group that has different operations around the world, you need to be aware of something called short-term business visitor reporting. So you may have people who visit you just now and then from head office or from a subsidiary. And it's really important to know that as a UK employer, the revenue say that pay-as-you-earn withholding is due from the first day spent working for that employer in the UK, unless you have a short-term business visitor agreement in place. Now, having said that, you're not expected to know when someone from your German parent goes to visit a client in Edinburgh. That's not really working for you. If you have people coming to the UK from overseas entities, you need to be able to monitor that initially and then agree some sort of reporting with HMRC. Now, it's very likely that if you agree reporting with HMRC, it will be something called a short-term business visitors agreement. And what that aims to do is provide upfront double tax treaty relief for employees who just come here occasionally. So if you have subsidiaries in several countries and people come once or twice a year just to report back, or to come and see from head office to see your particular office in action, as it were, there will generally be no pay-as-you-earn due, but the revenue like you to at least be monitoring the number of days that people spend here. And this short-term business visitors agreement is how you can stop having to even think about operating pay-as-you-earn, but actually have an agreement in place that is revenue approved. And all you really need to do is make sure that someone keeps a simple record of days spent in the UK. So usually if you have one site, that's very easy, because quite often the receptionist will perhaps book a taxi from the airport or book the hotel. There will be some existing mechanism to record that already that you can just use for this. And generally, if there's no, if someone's here for less than 60 days in the UK, there'll be no pay-as-you-earn action and no reporting to the revenue. And under the agreement, we just get clients to send a one-liner just to say, yes, we've operated the agreement, but there's nothing to report here. And there is increased reporting for an increasing number of UK days. So it's in bands. As we move up to 183 days, you have to report more and more details. But if you haven't got one of these and you have people visiting you from overseas, not at the moment, obviously, it is a really good thing to have in place. It can stop revenue questions when they conduct an employer compliance review. And this can't be used as there are 3 instances. You can't have a short-term business visitor to include directors. Under double tax treaties, essentially, there's no de minimis for directors. So if you have an overseas director who comes to the UK frequently, or even not frequently, they will need to have pay as you earn operated on a proportion of their income usually. And there are mechanisms where you can do that. So it can't apply to directors under any circumstances. It can't apply to branches or employees who work overseas where there is not even a branch. So because there is nowhere overseas to make the deduction for their salary, and it can't work in countries where there's no double tax treaty agreement, the biggest of which really is Brazil. So those instances, you can't have a short-term business visit agreement, but you can have a special short-term business visitor agreement that does involve one annual pay-as-you-earn entry each year. But we could, if you want to know more about that, you can get in touch. But the other slides, if you flick through again, Melissa, just highlight really a checklist of things for you to think about if you have people moving between the UK and overseas. And on that note, I'll hand over to Tim, who will cover some of those.
Thank you so much, Kate. That's really interesting. We've had a couple of questions in, but what I will do is proceed with the sort of legal side of things, and what we'll do is try and pick up questions when we have time at the end. So the legal side of things. Let's move on to the first slide. I guess before we get into the legal side of things, there is a really commercial consideration first and foremost. It's obvious to say it, but it is of course a time when many employers are reflecting on what kind and size of workplace they're going to need going forward. Do you need everyone back in the office? And if so, why is that specifically? Is it because of the type of work that you do that makes remote working impractical, or is the team dynamic, for example, such that fragmented virtual working is really not going to be good for the team and therefore not good for business? Or on the other hand, has lockdown actually shown you that actually as a business you don't necessarily need the office of old, and that actually work can be done perfectly effectively from home? I think that many employers are going to end up with a kind of hybrid position where remote working takes a much bigger role than it would have done pre-COVID. From an employment law and employee relations standpoint, I think it's unlikely that any staff are going to be able to claim that they're contractually entitled to work from home or contractually entitled to return to office working. And the vast majority of employment contracts are going to contain what's called a mobility clause, which enables the employer to change the place of work within reasonable limits anyway. The only complicating factor can sometimes be where a place of work is being moved very far away. Questions might arise over whether there's a place of work redundancy. You might also have staff that have health conditions that may need to be taken into consideration when you're setting the workplace or when you're changing it. So as in most employment situations, the way to avoid unnecessary sort of unrest or opposition when making changes to the workplace is usually best done by consulting with staff first, and it usually helps to sort of flush out any issues which there might be. And if we move on to the next slide, really we can't talk about mobile workers or agile working without mentioning the cornerstone in employment law of the flexible working regime. And as COVID ends and the restrictions on bringing staff back to the workplace end, we see there being obviously an increasing number of circumstances in which you receive requests from staff to continue to work from home for most or all of the time. And regardless of whether that's a request to work nationally or internationally, those requests should be dealt with in the first instance under the existing flexible working regime that we have. And I've just put a few pointers on this slide, which I'm sure many of you will be very familiar with. Obviously, in order to make such requests, you have to be an employee, you have to have at least 26 weeks continuous service, and you can only make one request a year. And from an employer's perspective, again, I put a few pointers there to help. You should really be requesting that these requests be made in writing. Obvious though it may seem, you've got to consider the request fairly. You've got to discuss and consult with your employee about the dynamics of the request that they've made. And really, you should only be turning it down on the basis of certain defined bases of rejection, which if we move on to the next slide, we'll just have a quick look at. So there they are in all their glory, 8 reasons that you can give as an employer to reject a request to work flexibly. I would say that probably grounds 3 and 5, so the issue of quality or standard suffering or performance suffering, I would say in my experience that does tend to give quite a big leeway to an employer to reject a request if it's really not practical and pragmatic to grant it. But if we move on to the next slide, obviously a word of caution when you're considering these requests. The main thing to bear in mind is that you're not arriving at a decision that is discriminatory in any way. I guess if you're looking at a request to work internationally, the danger could be in treating overseas nationals in a different way than you would to UK employees. Is it necessarily impossible for international employees to work remotely from abroad? And if so, why? You need to be seen to be documenting and to be arriving at a conclusion that you can objectively justify. And of course, in the post-COVID world, I guess it's kind of tougher, or it could be potentially tougher to justify refusing a request. We've now had a year of remote working. There might be perfectly cogent reasons why you can't continue to work in a remote way, but you as employers may have put in place systems and processes which frankly weren't available before, and might actually mean that going forward at least an element of home working is now viable where it wouldn't have been before. And what I would say in relation to overseas working arrangements is that you might want to confirm certain things in writing to an employee. The first thing I would say, really echoing what Kate said, in terms of tax, will the employee be liable for any additional income taxes or social security, which might be levied because of their decision to work for a short period overseas? And if so, you might want to make it clear that you as an employer are authorised to make additional deductions if that's necessary. And you might want to set out that actually the employee is responsible for making personal tax declarations in the host country if that's what needs to be done. So there's tax firstly. The risk of establishment, obviously Kate mentioned it earlier. I'm certainly not an expert in the issue of foreign establishments, but in terms of a UK employment perspective, you might want to make it clear, again in writing, that the employee is solely working for the UK business during the period in which they're overseas, and that they don't have any authority to sort of enter into contracts on behalf of the UK employer, and shouldn't hold themselves out as having any such authority. So that's important to bear in mind as well. So tax, corporate establishment, health and safety. So you might want to set out in writing that the employee takes responsibility for ensuring that they've got the sort of necessary technology and arrangements in place to enable them to work effectively and safely from home. and you might want to talk about the employee perhaps accepting the fact that they're working from home at their own risk, and that you as an employer won't be liable for any sort of losses that they suffer as a result of their request being approved. You might also want to set out that the employee has to comply with public health guidance, both in the country in which they're located and back in the UK. So that's important to bear in mind. And lastly, law. You might want to reconfirm, even though your contract of employment that the employee has a jurisdiction clause in it which states that UK law applies, you might want to reconfirm that the employment contract remains subject to UK law and jurisdiction. So let's move on to talking about choice of law. Let's move on to the next slide. Deciding actually what law applies when you're talking about international working is quite a complex area, and could probably take up a whole session on its own. And I'm going to try and sort of briefly take you through. I mean, the basic starting point under international law is that the parties' express choice of law will be respected for the purposes of deciding the applicable law of the employment contract, so the contractual rights. So it depends on what the parties choose, and invariably you will have a jurisdiction clause in employment contracts which sets out that English law, UK law applies. But that choice of law is not going to deprive a worker of the protection of mandatory laws. So, for example, an express term in the contract that French law applies to the contract for an employee that's working in the UK, that's not going to deprive that employee of any unfair dismissal protection that they might have in the UK. So to determine what laws apply, you've got to look at the country in which the employee habitually carries out their work when they're performing the contract. It might be that actually temporary employment in that other country is not going to change the habitual place of work, but you'll need to consider it beforehand. And it all comes down to lots of considerations: length of time, the kind of things that they're doing whilst they're abroad. If there is no habitual place of work, which is possible, then you look at the law of the country where the place of the business through which they're engaged is situated. So the place of business. But either of those can be overridden if actually it appears from the circumstances as a whole that the contract is more closely connected with another country than either the habitual place of work or the place of business. You might have an employee that's habitually working in a number of countries. For example, a lorry driver. And if that's the case, then you look at the country where their activities are centered, or where they sort of carry out the greater part of their activities. As Kate said before, I think the courts will take particular account of the country where the individual employee pays taxes on the income from their employment activity, and things like where they're covered by a social security scheme, and things like sickness insurance. So there are lots of different considerations, frankly. So it's not, I guess what I would say, I won't get too bogged down in this because it is quite a complex area of law, but what I would say is that for the purposes of this webinar, the issue of whether local laws apply is quite an important one. And I would recommend that you don't simply look at the contract and say, well, okay, it's governed by UK law, because that would solely relate to the contractual rights. So it's an important issue to cover off. So if we move on to the next slide, we should have immigration issues. Now, I guess it might not occur to employers that you'll need to ask questions about immigration status and the right to work wherever it is that your employees are going. It goes without saying, of course, that since the end of free movement, UK nationals now have to have immigration status in the EU in order to work, and I'll try not to shed a tear as I say that. It's possible that they might not have thought about that, or they might simply be intending to work temporarily on a remote basis as a visitor in another country. Think of our lucky individual who works on the Costa del Sol. If that's the case, is it legally possible? And just to take Spain as an example, if a UK national goes there at the moment as a visitor, they're restricted to a certain range of permitted activities, things like obviously tourism, but on the business side of things, attending meetings, trade fairs, certain intercorporate activities. It's a fairly reduced range of things that you can do as a visitor. And although I'm not a Spanish immigration specialist, working remotely from Spain may risk a breach of Spanish immigration law. It might be unlikely that you as an employer are going to be dragged into or implicated in any such breach, but it's going to be best to avoid any complications and discuss your plans in good time with your relocating employees. What about non-UK nationals? So similarly, non-UK nationals may also need a visa in which in the country to which they want to relocate. Also, what about non-UK nationals' immigration status in the UK? If they currently have immigration status here, are they going to lose that status whilst they're abroad? For example, if they're currently sponsored as a skilled worker, will their visa expire whilst they're abroad? If not, if they return before the expiry date, will they have been away for so long actually that their immigration permission risks being cancelled once they return here, because it's actually evident that they're no longer working in the UK. These are questions which need to be bottomed out before you agree to such an arrangement. Also, something to mention on the immigration front is those non-UK nationals who have status under the settlement scheme. So they either have pre-settled status. This is the new scheme for European nationals who are in the UK, who have been living here as at the 31st of December of 2020. You're either granted pre-settled status if you haven't been here for 5 years, or settled status if you've been living here continuously for 5 years. And the impact of absences from the UK is quite important. So if you're away from the UK for a continuous period of 2 years, then you lose pre-settled status, and you lose settled status if you're outside of the UK for 5 years continuously. But it's people with pre-settled status in particular that need to be aware of the absence rules. If they're outside of the UK for more than 6 months in any 12-month period, during that 5 years it takes to qualify for the full settled status, then they're generally going to have to start the 5 years all over again. And they actually may lose the right to upgrade to settled status entirely because of the way that the immigration rules have been drafted. So that the continuous 5-year residence period has to start before the end of last year, unless there are certain exemptions. COVID, they might be able to argue sort of COVID, and that's the reason for the absence, and therefore that there should be a discretionary grant of settled status despite the absence, but that's not guaranteed. So those kinds of questions will need to be borne in mind both by employer and relocating employee. And of course, if they're coming back to the UK as visitors, similarly to the case of someone working overseas without any immigration permission to do so, those who are coming here as visitors will need to stick to a certain range of activities in the UK permitted under the current visitor visa rules, or they will need to have immigration permission in order to return back to the UK. So going on to the next slide very, very quickly, I guess, just on a practical point, returning to the UK at the moment, although of course, hopefully before too long, all of these restrictions will sort of fall by the wayside as COVID comes back under control. But there are certain administrative things which people returning to the UK need to tick off, and absolutely that's something that you may need to consider as part of your flexible working request, that actually if they are required to come back to the UK now and again, is it at the moment going to be practical for them to have to quarantine, or have to be in a hotel if they're coming from a red list country? So those are certainly considerations which need to be borne in mind. If we move on to the next slide, so I'm just going to talk very, very briefly about UK staff who are involved in delivering services on a short-term basis overseas. So, for example, your company is engaged in a contract and it's necessary to send UK staff or non-EU staff over to the EU in order to deliver that service. Now, you could come within the business visitor rules, as I've just explained, provided that you keep within a limited range of activities. Your staff keeps a limited range of activities when they're in the EU countries. If not, and I'd recommend that anyone who has a problem with insomnia, open up the EU UK trade agreement, which was signed just before Christmas, and that you read the rules on contractual service providers and independent professionals. So we have those two categories of staff who could potentially go to the UK, go to the EU for a period of up to 12 months, provided that they can come within certain requirements. So we're talking about staff, particularly on the contractual service provider front. It has to be staff who've been offering or engaged in the same type of services as you're offering under the contract in the EU for at least a year before their application, because it is a visa application that will need to be made. And they have to have a certain professional track record of 3 years, and they can't be paid a salary from the end client in the EU. And the restrictions on independent professionals are even more stringent. So a longer length of professional experience is required. So if you can come within those definitions, obviously you have to make a visa application, and there are a certain number of country-specific restrictions as well. So not only will you need to look at the activities which you intend your staff to be doing as contractual service suppliers, but you will also then need to have a look at what country-specific restrictions have been imposed for that type of activity. So it's a fairly complex area as well. Now, if you're talking about those contractual service suppliers coming into the UK, we have the temporary worker visa route, where effectively the client in the UK can stand as the sponsor, and they can sponsor, if they're registered as a sponsor, they can sponsor those individuals into the UK. So finally, what of course I have to mention is the new, if we move on to the next slide, the new points-based system as it applies to European nationals. Obviously, for those who don't work or haven't been living in the UK as at the end of last year, those nationals who are coming from European states into the UK will invariably now have to be sponsored under the new points-based system. And that sponsorship will be under the skilled worker category. It is a more flexible immigration system, so you don't have to advertise positions anymore. The salary thresholds are lower. There's a wider range of jobs that are available for sponsorship. So it is much more flexible than the system that we had before the 1st of December of last year. The flip side to that is that it comes at a price. Obviously, it is quite an expensive endeavour actually to sponsor individuals into the UK, whereas it would have been free effectively under the principles of free movement when we were part of the EU. Now you will have to, as a company, register as a sponsor. You'll have to pay an immigration skills charge, and of course there's all the visa application fees to pay by the individual and their family members if they're bringing family members over to the UK. And the starting point under the points-based system is to look at, firstly, the job which you intend to sponsor an individual for. Is it eligible? Is it a job that is within the Home Office categories of eligible jobs to be sponsored? Is the salary sufficient in order to pass the salary thresholds? And does the individual have the English language capability and the necessary proof in order to meet all of the immigration rules in this particular category? So quite a few legal issues to resolve when you're looking at moving people around the world, and particularly to and from the UK. So I think that's all that I had from the legal, the employment and immigration side of things. Kate, there is one question which was received on the tax side of things. What if an individual works as self-employed or is a contractor from a different country, so they're not on the company's payroll? Would you have any?
Yeah, there's probably been a few more since you looked, I think. So we'll work through as many as we can. If you've got someone who's self-employed or a contractor, it probably depends whether they, from a UK point of view, it depends whether they work or not in the UK. So if they are working in the UK, then you will need to think about all the usual employment status, IR35 type considerations to see whether they have anything, one, that's taxable here, and two, anything that could need to be on a payroll here. If they're overseas, most other countries have similar things to IR35 or employment status issues. So, for example, we've looked at individuals in Spain and the USA lately, which have very similar provisions for sort of anti-avoidance, where you engage people through as a contractor or self-employed. So you'd really need to look in the particular country where they usually are to see if there's anything there. And then the UK, it really will depend on how often they work here, whether you need to consider their status or not, and what you need to do with them. So I hope that's enough for now.
There is one here about, which is quite good, possible to block or forbid requests for international flexible working. I think that's when we sort of move into the dangerous territory of potential discrimination. I would recommend that if it is the case that international flexible working simply doesn't work, and there might be reasons, objective reasons why that's going to be the case, but that you properly document them and assess actually why that's the case, and not simply give a sort of blanket prevention of flexible working on an international scale.
There's another one for you, Tim, which says, is the employer obliged to pay for home office equipment such as printers, chairs, monitors?
No, but it might be reasonable to come forward with buying such equipment, and of course you have to be consistent across all the employees that you have. So no, but there might be a health and safety or health reason why actually such equipment has to be provided. So I think you should probably approach things on a case-by-case basis, and if there is a specific reason why a certain employee needs support, perhaps not to provide that could be a bit of a risk.
There's a query from Julie who says, we have a request for flexible working nationally, so I assume that's in the UK. We normally have a review period if we accept the request. How does this work if someone moves to another location and then it is found it doesn't work out, given that the individual has relocated already?
So I guess a review period. So I'm guessing that if there is a review period, then there will be a sort of trial period. And if that's the case, then, and if they move back within the trial period, I mean, that's fine. I mean, granting flexible working request does lead to a change in the contract, depending on how you agree that with the employee. So, if they've moved beyond the trial period, or if we have moved into that contractual change, then it would be effectively another flexible working request to revert back to the original position.
Got another one where a Spanish employee has decided to stay in Spain, which why wouldn't you, basically? We've determined the payroll side of things and established all of that in Spain, but unsure about the contract position, especially, for example, regarding things like Spanish bank holidays.
Yeah, I mean, I guess what is perhaps a recurring theme of these situations is that you often need to take local advice. And when I was referring to those mandatory laws previously, if this is a long-term arrangement, then you really should seek local legal advice about what the mandatory law provisions are in Spain. For example, if people are entitled to have certain days off under Spanish law, then that will have to be incorporated. Obviously, there is a question of the longer an arrangement is for, the more likely it is that local Spanish laws will apply. So it's often a case of taking a steer from local Spanish employment lawyers who would probably be best placed to answer that.
We've just had one client who had exactly that instance, although the individual was British moving to Spain, and they have had to have a contract, and it was particularly around holidays and things that they felt the company would be better protected to have a Spanish contract.
It's often the case that local lawyers will recommend that a local law employment contract is put in place in order to reflect the mandatory rules in place in that country. So I'm conscious that we're past 10 o'clock and we probably run out of time. What we do have is a fair few questions that have come in, and we will try our best to answer them and send out some pointers relating to those questions as we in the next few days. It only remains for me to thank you all for attending this webinar. We hope it's been useful for you. Thank you, Kate, for giving us such a very interesting spin through the tax and accountancy and social security side of things. And we hope to see you very shortly for more webinars.